But my top story tonight is India's big diplomatic offensive against Pakistan on the global stage over the hanging which Pakistan intends to go ahead with of Kulbhushan Jadhav. Today the two sides were at the International Court of Justice in Hague. 11-judge bench today allotted 90 minutes each to both India and Pakistan to present their arguments in the Kulbhushan Jadhav case. India's counsel Harish Salve and Pakistan's lawyer Khawar Qureshi presented their arguments before the court. India insisting that Pakistan had violated the Vienna Convention by sentencing Jadhav to death without providing him consular access, and Pakistan insisting that spying and terror which they accuse Jadhav of does not fall under the Vienna Pact. India further arguing that Pakistan denied consular access to Jadhav despite 16 requests. Pakistan saying spies are not eligible for consular access. India seeking annulment of the death sentence and a stay on it. Pakistan stating that this matter isn't under ICJ's jurisdiction. They have their own laws to deal with it. Pakistan trying to present Jadhav's confession video, which the court denied them the permission to watch. Mr. Salve, in his argument, had termed the tape doctored. India has also sought, as I said earlier, a provisional stay on Jadhav's hanging. Listen in first to the two sides.
India's position has been and continues to be that Jadhav was kidnapped from Iran and appears to have been framed based upon a confession extracted from him when he was in military custody.
The chronology is as follows. Commander Jadhav was arrested in the southern province of Pakistan, Balochistan, which is mineral rich and unfortunately has seen violence all too often. He crossed in from Iran bearing that false passport.
An Indian national was in military custody. He was made to confess, and then he was tried for offences and awarded death penalty. The prejudice caused by egregious breach of the Vienna Convention assurances provided for in Article 36 is writ large and does not merit any further elaboration.
There are plainly qualifications within the Vienna Convention itself which point to the exclusion of the operation of the Convention with respect to acts of this nature. Article 55 makes it clear that there must be no interference in the internal affairs of the receiving state. That itself makes it plain that if an individual is accused of espionage, terrorism, consular access, which may involve compromising evidence, which may involve exacerbating the threat for the receiving state because of coded communication, cannot possibly be anything other than a breach of Article 55.
That after his arrest, a confessional video was recorded on 25th March, the FIR was registered on 8th of April, the accused was interrogated in May 16, and in July 16 a confessional statement was recorded before a magistrate. The court-martial recorded summary of evidence on 24th September 2016, and in 4 proceedings culminating on 12th February 2017, the trial was over. These facts establish beyond the shadow of a doubt that the trial was conducted without informing the accused of his rights under the Vienna Convention, without granting consular access to India, in denying the accused and India to arrange for legal representation.
The passport plainly requires explanation. There is the confession, which is in the bundle that was given to the Indian authorities, together with, significantly, the United Nations Security Council Resolution 1373.
It was an act of desperation by grieving parents. The parents of Mr. Jadhav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 27 April 2017 for his personal intervention in the matter, but there has been no response.
To use the International Court of Justice as a stage for political theatre, we regret that this has been done. We will not respond in kind. Our counsel, Mr. Qureshi, will explain why it was wrong for India to invoke the exceptional provision Mayer's jurisdiction of this court.
So there you have it, the two sides battling it out in The Hague at the ICJ. Meanwhile, the man who's been the center of it all was Harish Salve. We spoke to him. Gaurav Sawant, our correspondent who's in The Hague, spoke to Harish Salve a short while ago. Let's listen in to what Mr. Salve had to say was the core of India's case.
They say, a healthy mind in a healthy body. We saw Harish Salve's healthy mind at the International Court of Justice. He is with me here at the gym for the healthy body. Mr. Salve, we saw the healthy mind in court. Now it's the healthy body you're working on. Okay, so the gym speed is pretty good. He's on the treadmill. How long are you on the treadmill today? 1 hour, non-stop. Excellent. Does that help you in a court of law? How?
Cleans your head up.
Absolutely.
Stress buster.
This is a stress buster. Were you stressed at any point of time?
Always. It's a big responsibility.
It is. To save a human being's life.
Always.
How confident are we that, our points are getting across to the 11-member international community at the ICJ?
I think they did.
Does Pakistan have a case anyways?
That I'll tell you at 4:40.
So, Mr. Salve, Pakistan is in violation of the Vienna Convention. You've proved that in a court of law. You proved from past instances. Now, the judiciary goes by past instances, sir?
Yeah, precedents.
They'll go by precedents. And we have a strong case.
I hope so.
And so, which means, God willing, we will save Kulbhushan Jadhav from the gallows.
I'll tell you more at 4:40.
So what we see Mr. Harish Salve do at this point of time is exercise. Exercise, he'll be back 1 hour at the treadmill, then he'll be back. You'll also be countering Pakistan's contention. No.
That's not the style.
Okay. So now we'll only hear Pakistan and...
This is for provisional measures. They've heard our case. They hear the Pakistan's case. Take a view.
And how soon can we expect a verdict?
Pretty soon.
Tentatively, a time frame? Couple of weeks. Mr. Salve, as always, many thanks for speaking to India today. So 1 hour at the treadmill, then back at the International Court of Justice at The Hague. Gaurav Sawant at The Hague for India Today.
Meanwhile, let's get a look at the other side, because I spoke a short while ago to Pakistan's Attorney General Ashtar Osaf. He is claiming Pakistan will not accept the ICJ's jurisdiction. Listen in to my exclusive interview with the Pakistani Attorney General.
Mr. Osaf, how do you describe the proceedings that have taken place today in the Pakistani court? Would you agree that Pakistan suffered a setback because the confessional video of Kulbhushan Jadhav was not allowed by the court to be aired?
There's no setback. There can't be a setback if the court decides not to act as a court of appeal. This is exactly what Pakistan wanted the court to say, that the court is not going to sit in appeal to the proceedings in Pakistan. And therefore, if somebody is trying to dub this as a setback, he's sadly mistaken.
The reason I'm asking you is that Pakistan did make the attempt to try and ensure that the video was played. The court rejected it. So, to that extent, would you concede that that the strategy of airing the video failed?
The strategy was to make the court say that it did not want to see the video because it was not acting as a court of appeal. And it worked. It was not for the purpose of telling the court that the video had any mixes. This is a strategy which is used by counsel for the purpose of determining as to how the court will proceed in a particular manner. So therefore, it is not a setback. It is something where I think Pakistan was able to make a punch.
Okay, Pakistan insisting the fact that the confession video could not be played in the court was not a setback. The big questions tonight. Will Kulbhushan Jadhav get natural justice or not and be given consular access as any citizen you would expect under the Vienna Convention? Has Islamabad violated the Vienna Convention? Did Pakistan catch India off guard by tweaking the ICJ terms? Was India able to present its case forcefully enough? Has India been able tonight to corner Pakistan globally? These are some of the questions that we will raise tonight. Joining me now, the former High Commissioner to Pakistan, TCA Raghavan. He was High Commissioner till last year. Dushyant Dave, Senior Advocate at the Supreme Court with me. Raj Chengappa, Group Editorial Director, Publishing at India Today, is with me, and Zafar Hilali, former diplomat from Pakistan, is with us. I also hope to be joined by George Perkovich, one of the experts from Washington on India-Pakistan relations. To you, Mr. Hilali, first. Would you concede that Pakistan today, by not accepting the jurisdiction of the ICJ, finds itself increasingly isolated? Here is a human rights violation which Pakistan believes cannot come before the International Court of Justice, saying India cannot invoke this cause of that this is an exceptional circumstance. Are you willing, Mr. Hilali, to concede that Pakistan is flying in the face of the Vienna Convention and against established international conventions, sir?
Well, first of all, we won't have to wait very long to get the court's decision on that. So why try to second guess them? But I will say 2 or 3 things.
Yes.
The first thing I would like to tell you is that it's a bit rich, isn't it, on the part of India, which has refused ICJ jurisdiction over all its dealings with Commonwealth and ex-Commonwealth states in 2000 and God knows when, to now insist on the fact that the ICJ has jurisdiction in everything except the Vienna Convention and this protocol. You have rejected the ICJ, but now you think that the ICJ
sir, I am a student of it. Sir, with due regard, sir, with due regard, I am a student of international law who spent 3 months as an intern in The Hague 30 years ago, and cases involving violations of Vienna Convention do come to the ICJ. In that sense, this would be a fit case with due regard for the jurisdiction of the ICJ, which Pakistan today is not accepting, sir.
You missed my point. My point was, in every other regard, except this, you have rejected the ICJ, and now you say you must have the ICJ. Number one.
But another point I'd like to make. You're trying to take advantage of technical things. Like, for instance, there's a bilateral treaty between Pakistan and India which says specifically that spies are not to be treated as nationals who are ordinary nationals who are arrested. Spies cannot have access and all. That treaty was signed in 2008. Now I think your counsel is saying that treaty should have been registered at the UN under Article 100 of the Statute of the Court, because that was not done for some reason. Therefore, Pakistan cannot now use that.
1 minute. Let me take that while we get the line fixed to you, to my Indian colleagues, to ask that question. To you first there, TCA Raghavan. Does Pakistan have a case to say that they claim that Mr. Jadhav is a spy and the Vienna Convention will not apply to spies and India is a signatory to it? That seems to be one of the core arguments that Pakistan made. They even showed the passport which they claim was the false passport under which Mr. Jadhav was travelling. Can one buy the Pakistani version that spies will not get consular access if indeed, as they claim, that Mr. Jadhav is a spy?
Well, this point was made by the Pakistani counsel, and now really it is for the court to rule on that. But I think if one takes an overall view of the Vienna Convention, it does not exclude any category of person at all. And to say, even assuming that the person is a spy, that he is not entitled to due process and can be sentenced to death by a summary court-martial, I believe would be going against the very spirit of the Vienna Convention.
Again, the spirit of the Vienna Convention. Dushyant Dave, this seems to be Pakistan. There are twofold arguments that Pakistan made in the court today. One is the argument of jurisdiction, claiming that the ICJ has no jurisdiction in this matter. And number two, they claim that they are dealing with a spy here, not a businessman as India claimed, and therefore Mr. Jadhav will not get the benefits of the Vienna Convention. Do you believe that Pakistan is violating, if not the letter, then certainly the spirit of the Vienna Convention?
I think Pakistan is violating both the letter and the spirit of the Vienna Convention. There is no doubt that under Vienna Convention and Article 36(1), which has been pressed by India, the jurisdiction certainly lies with the ICJ. Secondly, insofar as the question of Jadhav being a spy and therefore not amenable to the Vienna Convention is concerned, I think the argument is completely non-existent. The treaty, Vienna Treaty, does not really single out spies and exclude them from the purview of the treaty. I must also tell you that International Human Rights Convention also recognizes that even a spy is entitled to be treated humanly and is entitled to, the protection of the laws. So I don't think this argument is really a good argument which Pakistan is raising. The argument of the 2008 bilateral treaty is understandable, but these two arguments certainly are not really very strong in favor of Pakistan. India has rightly invoked jurisdiction, and India has a right case to say that Jadhav should be subjected to the consular visitation rights, and without that, if the trial took place and sentence was given by a military court, then certainly it's not really in accordance with law and the treaty.
Would you also say, therefore, Mr. Dave, that the manner in which Pakistan tried to bring out the confession video, a video which Mr. Salve made clear he believes was the framing of an individual, it was done under coercion. The Pakistanis refused to allow that video to be, the Pakistanis were not allowed to put that video before the ICJ. Now Pakistan is trying to give a spin to that by claiming that this proves that the International Court of Justice cannot be a court of appeal. In your view, has Pakistan violated again the spirit of the Vienna Convention and ICJ proceedings by trying to put out a confessional video that by all accounts was brought under duress?
Well, there is no doubt about the fact that, and one would be naive, even Pakistan would be childlike to say that confessional statement is really an admissible piece of evidence. Anybody, who is left, with the investigating agencies in the manner that Mr. Jadhav was left, could have been easily, coerced into giving a statement which may appear on the television to be free and fair. But we all know what must have preceded before that statement. Therefore, it's really, I think, absolutely unbelievable that Pakistan would really base its case on the confessional statement. And I think ICJ was right in saying that it should not be allowed to be played. Therefore, to that extent, Pakistan certainly has been told that please don't rely on this statement, although it's part of Pakistan's annexures to its reply, as I could gather from the defense argument on behalf of Pakistan.
That is the point, Mr. Hilali. By trying to play that confessional video, a video which by all accounts, and Mr. Salve made the point forcefully, has been done to frame an individual, done under coercion, Pakistan was trying to stage a bit of political theatre in an ICJ, in an International Court of Justice, to bring a confessional video which by all accounts has been brought under coercion, shows your country in very poor light.
I think a confessional video is useful, and the people who listen to it can tell, I think, by the demeanor, deportment, speech and thought of the person confessing, whether that is really the outcome of torture, etc., or whether in fact the man is speaking what he believes. But let's leave that out for a moment. Yes, indeed, Mr. whatever his name is, Jadhav, is entitled to due process and a fair trial. Indeed. In fact, he has...
Is the due process and the fair trial?
And the trial...
If he is entitled to a due process and fair trial, at the very least 13 consular access requests should have been accepted. Why were basic consular access requests not accepted?
Let me finish. Please let me finish. I did not interrupt you when you were going on and on. Let me just make my point. And indeed, the trial of Mr. Jadhav has not...
Mr. Jadhav,
the trial has concluded, but the procedures...
Not Jadhav, but
procedures have not... Whatever it is, the procedures have not concluded. He has a lawyer, he can still appeal to the Supreme Court, and if the Supreme Court turns it down, of course, there is the mercy appeal to the President. Now, the fact of the matter is that we wanted to make the point that the court has been set up under the Constitution of Pakistan. The court is a court which is legal, and it is not a typical military field marshal court. He has a lawyer,
military field marshal
he can
court.
appeal,
Sorry to intervene.
he has to...
It is a military court set up to try terrorists.
It's a military court. It's a military court. Indeed, he is a terrorist.
Which
he
does
himself,
not, it's a military court which works under a certain opaqueness. It's a military court which works under opaqueness.
He has been caught with a whole gang of people who have confessed to peddling arms, distributing
the German ambassador says he was found on the Pakistan-Iranian border. Your lawyer today in court says he was found in Baluchistan.
The German ambassador, but for God's sake, the next time you'll ask me to believe the Vietnamese ambassador.
I'm not supposed to believe the German ambassador.
For God. No, why should you believe him? Yeah?
Sartaj Aziz, your advisor in December this year, said there was insufficient evidence against Mr. Jadhav. Sartaj Aziz, your premier, said there was...
I'm glad he said it.
So suddenly in 4 months, the evidence is good enough for him to be hanged.
Why not? In 4 months, you can get evidence in 1 month, 2 weeks. Indeed, it was true at that time. That's why we didn't make a big fuss about it. We only made a fuss about it when we had corroborating evidence to say that everything to which he confessed could be corroborated. People have died, children have died, women have been killed, innocents have been killed.
I ask you one last time, Ambassador Hilali, I ask you one last time, none of that prevents you from granting consular access. If you don't grant consular access, that reduces the entire court proceedings and your concept of a fair trial to a kangaroo court.
But don't you understand, consular aspect does not change the sentencing or the conviction.
But at the very least, you start with consular access.
What
is Pakistan hiding?
About the conviction
what does Pakistan want to hide by denying an Indian citizen consular access?
Because under the bilateral treaty, both of us had agreed that spies of each country would not get consular access, would not be treated on a par with nationals of each country arrested by the other country, because they are a particularly odious group of people.
1 minute,
now,
1 minute, 1 minute. Let me ask that to Mr. Raghavan. Mr. Raghavan, is there any truth in that you would, in a similar situation, India would not grant consular access? We've got the case of an Ajmal Kasab, a terrorist who was granted legal protection. Just a minute. Let me get in, Mr. Raghavan. No, let me get in, Mr. Raghavan, sir.
That's not the question you should ask. You should ask another question.
No, 1 minute.
Please ask him whether India signed such a treaty or not.
Has India in the past, Mr. Raghavan, given consular access, including to the likes of Kasab? Was he not given full legal benefits, even though he was caught red-handed in 2611, Mr. Raghavan?
You're quite right. The central feature in this case is the absence of due process, and absence of due process in the most extreme form, because a summary court-martial is normally used by armies to enforce discipline in their own ranks. It's not meant to be used against nationals of other countries. So the absence of process, which is a summary court-martial, which is why in fact the whole issue of consular access attains the importance which it does have. I believe there is a misinterpretation around the 2008 agreement. The 2008 agreement is an agreement on modalities of how to enforce the Vienna Protocol in a positive way between India and Pakistan, and various administrative steps have been agreed upon in that particular agreement. Certainly there were no military courts in Pakistan in 2008, and the idea that foreign nationals could be tried in a summary way by court-martial had not entered the heads of those who had drafted and signed the agreement. I think these facts have to be kept in view rather than taking too narrow a view or too legalistic and technical a view of these proceedings.
That's exactly it, Mr. Hilali. The precise point today made by Mr. Raghavan, that there is no concept of due process, there is no visible commitment to due process. At the end of the day, an Indian citizen is being denied due process. I mean, Pakistan today, by doing this, is isolating itself. You can talk on the merits of the case, but I am focusing on due process, sir. At the end of the day, there's a concept called natural justice in law.
At the end of the day, an Indian naval officer who committed terrorism and murder has not been tried by a summary court-martial. You yourself know very well that Mr. Artaz Aziz said some months, 4 months ago, that the evidence that they had at that time was not complete. He could not come to a conclusion. That's hardly a summary trial. That's hardly a kangaroo court.
A summary trial,
when all
a summary trial is conducted when it is conducted without proper hearing. Within the space of 15 days, the trial is completed and a man is given the death sentence. That's the precise point. None of these points. I'm sorry, Mr. Hilali. Please do not mislead our audience by saying this was not a summary trial. Let us not mislead audiences.
When you say summary trial, when you look 3 months, it could be, you may consider that a very short period of time. Perhaps if the evidence was there and it was, you know, all dusted and done, perhaps it should have taken not 3 months, but 1 week. My point is something else. Please understand. The idea is not to have caught a man who did nothing only and blame it on India. Like that you can go and catch anybody, kidnap them and come and do these sort of things. We caught a man who had for months lived in Karachi also, come to Karachi, stayed there, crossed the border repeatedly,
Mr. Hilali,
had a false name,
Mr.
a false
Hilali,
profession.
you and I are now operating on different planets. I am focusing on due process. To my mind, that is the critical question. Raj Chengappa of India Today, do you believe that that is where Pakistan is misleading the ICJ, misleading the world at large, that, and today on TV also, that the real question is due process. Where is the due process being followed in this case?
Well, I think both sides today presented their arguments well, Rajdeep. And of course, the court will decide pretty quickly. But let's look at the gains that India has done by proceeding to the ICJ and making these arguments. Firstly, it has brought international spotlight on Pakistan's actions. And clearly, as you said, there's a lot of questions that can be asked as the way the entire trial was conducted, the summary nature of it, and the final judgment that was given in terms of execution. Then Pakistan makes the statement in court today that says that, look, why is the ICJ providing provisional relief to India when India actually can take all the relief that the ambassador was talking about, which included going to the Supreme Court and presidential pardon that should take 150 days, which means that India has bought time, according to Pakistan's own admission, that they cannot hang Mr. Jadhav till August or September, which again gives India time. The third argument I think India put forward pretty well was that in terms of jurisdiction, they argued very specifically about the Vienna Convention. Of course, they did ask for relief, as it was found in the Mexican case, where the ICJ did provide relief and asked the US to relook at the sentence. They even asked for that. But if India goes through with this case, and you know, there's good possibility that it would, then we would find that at least we would get access, consular access. And I think Pakistan exposed itself on two fronts. One was trying to play that video, which, you know, even in ISIS, we've seen what they do with these confessional videos, and that was absurd. And the other, I thought, was that their limited arguments in terms of the jurisdiction that was there, going back onto the bilateral treaty that was 2008, trying to argue against on the Commonwealth front. I mean, there is clearly, we can see, and world attention on this, is that there's been a summary trial that is on. You know, India has a good case, and I think they put it forward well today. Of course, as I said earlier, Pakistan...
Let me just take that to Mr. Hilali. Mr. Hilali, would Pakistan not be embarrassed tomorrow if the ICJ were to tell you that there must be a provisional stay? Or does it not matter for Pakistan today that the ICJ might well rule against you? If they do, will you take this as reason enough to keep to stay the death penalty? Or is Pakistan determined in a way to go ahead with this, that you've made this a prestige issue of sorts?
First of all, I think that when you say the spotlight is on Pakistan, I think, I'm sorry, the spotlight again is on the actions of Mr. Yadav and the murder and the terror associated with him, Jadhav. And associated with his name.
Yes.
Yeah, whatever it is.
No, sir, he has a name,
associated with his name.
Yes.
Kulbhushan, how about that? Are you happy with that?
I'm happy with that.
All right. As long as you and I know who we are identifying, I think I think the world knows. Secondly, yes, consular access, if you feel that would make a big difference, and if the court feels that you can have consular access, but that won't make a dime's difference.
Whether it
all
does,
that it will do is you will be able to say all the hundreds, and what will it do?
Due process.
The man has been sentenced.
Due process.
The man has been convicted.
The man has been convicted by a court which is a military court established for particular circumstances. This is not a military trial that you're conducting,
Yes, certainly.
Sir.
He has been convicted indeed by a military court set up under the Constitution of Pakistan for precisely the purpose of quick justice to terrorists and murderers, number one. Secondly, thirdly, let me just say this. The conviction of this man, the deaths that he has done, you know, people here are trying to compare it to Raymond Davis. You know,
please
we
put
will
the
never
evidence
in
in the
this
public
country
domain.
forget that.
My point, Mr. Hilali, if you have concrete evidence that Mr. Jadhav was involved in terror attacks, put it before the public. You have not chosen to do so. It lies behind the four walls of a military court. A summary trial takes place. You deny consular access, and then Pakistanis come before the ICJ and now here claiming in a way that he is involved in terrorism. I'm saying put that evidence in the public domain. Why is the evidence not put in the public domain? In public domain, I have Sartaj Aziz saying we do not have enough evidence. So either Mr. Aziz was lying to your Pakistan Senate or something dramatically changed in the last 4 months.
Well, let me just say, he said it 4 months ago.
Rajdeep,
and secondly,
may I come in at this
the
stage?
evidence that we
the
have
ambassador
has been
may
given
I just
to
finish it, Ambassador?
Yes, Rajchandgappa.
May I just come in, Ambassador?
Yes.
Just two quick points. You concede that, well, if consular access the court grants, you would be happy to do that. That's good. The second point, and I think Rajdeep made that very forcefully, is that there is clearly a lot of opaqueness in the arguments put forward. We still don't know the entire evidence that has been put forward to charge Jadhav. We don't know in what, the kind of circumstances that he has been arrested and put in. All this, if we are able to get, there would be a stronger point, and I think that's what India is also asking for. Apart from consular access, please show us the evidence. I mean, if you are so confident that Jadhav is a spy and did all the things he did, why aren't you putting it out? And I think the court quite rightly could argue for that.
That's right. That's exactly it. I want you to answer that, Mr. Hilali. Put the evidence. Do not call someone a terrorist without putting the evidence. You have not put the evidence. You are now telling the world he's a terrorist without putting the evidence. Not one shred of evidence that he was a terrorist was provided today before the ICJ. Because the military court's findings are not public findings. It's a summary trial you've conducted.
Why don't you keep these homilies to yourself?
I'm not kidding. These are not homilies, sir.
The answer to the question
These are not homilies. I'm saying put the evidence.
Oh, God. You always want the last word. I feel sorry for your wife, you know. Anyway, let me say one thing. The opaqueness which you talk about in a spy case, we cannot declare who we caught, how we caught him, and what were the links of our entire spy ring that we were able to unearth for obvious reasons. They are still there.
So you are a country, sir, with due regard, this is a country that lives in denial on Dawood Ibrahim existing there. Now you are in denial over the fact that it is a summary trial. You will not put the evidence of him being a terrorist in the public domain. I'm sorry, Mr. Hilali, and I'm talking as a journalist. I'm not wearing a tricolour. I am just questioning this as a pure journalist and someone who has studied the laws of the ICJ. There are summary trials and there are trials that are conducted with due process. And I'm sorry to tell you, sir, today that in Kulbhushan Jadhav's case, Pakistan has not made a case to show that they have evidence that he's a terrorist and that he deserves a summary trial of the kind your military court is doing.
You keep repeating that, and you don't sound very sorry for interrupting rudely.
No, I'm not interrupting, sir, but you're living in denial.
Frequently. Okay. I'm sorry, but you, oh God, now, I mean, if you are going to trade insults, fine. Let's
I'm not
start.
trading insults. I'm saying you're living in denial. I don't want to trade insults with you.
Yes, you are. What else are you doing? Why don't you listen? I went on a channel, I walked out the thing because They did nothing but trade insults.
I have not traded a single insult,
coming and trading insults. Now, if you don't agree with my argument, I can understand. I don't expect you to. I repeat again, in a spy case, the public evidence that is presented cannot reveal everything like in an ordinary domestic murder case or in a gang case. These are evidence which is acquired through painstaking work, contacts and many other things. So please understand, the evidence that has been acquired against Mr. Kulbhushan is evidence which we think...
I'm going to leave it there. I think we've lost our line, but I want to get a final word, Mr. Raghavan. Mr. Raghavan, is our case weak? Is the Indian case going to be weak because the passport that we have of Jadhav is under another name, that for several months India was not willing to accept Mr. Jadhav as an Indian citizen? Or do you believe that the Pakistanis will be cornered in the ICJ? A quick response.
I believe those questions will come up at a later stage, because this is just the preliminary hearing. But I do think one point was missed, which is, and this really brings you to the heart of the absence of due process, this confessional video, it not being shown, not being agreed to be shown by the ICJ. In fact, most municipal courts, whether in India or Pakistan, would not accept them as evidence, would not accept such a video as evidence. And this really brings you to the heart of the opaque process which has been adopted in this case from the very beginning.
That exactly, precisely is my problem, the opaque process of the entire judicial hearings in the Jadhav case. But I appreciate my panelists joining us on this program. I'm not here to be a crusader against Pakistan. I believe that we must play the role of neutral umpires. We are not judge, jury and prosecutor, but Pakistan at the moment appears to have not followed the ICJ procedure.